Good morning to all of you. Welcome to my legal ethics class. So, lot many cases are coming on Rule 11 and Rule 14 also. So, whenever you take up a case, you have to attend the case. You have to bring it to the logical end. Suppose, whenever anyone gives you a brief, you must give a frank and fair disclosure of the circumstances. Suppose, if the other party is known to you, the other party belongs to your village, if the other party belongs to your caste, there are so many factors will be there. You should tell the client saying that, Arey Baba, other party is known to me. You want me to continue or not? If you give a disclosure, it's okay. So, nothing was done in this particular case. Very senior citizens. This is a classic case called as V.C.Rangadurai V.C.Rangadurai Advocate versus D. Gopalan, 1978. It happened in the year 1978. So, actually, Advocate V.C.Rangadurai, he was a popular practicing advocate in Chennai. The complainant, Deva Senapati Gopalan. So, D. Gopalan, aged about 70 years, and his wife, Kamalammal. So both of them approached the advocate. They gave him two promissory notices stating that the other party is not giving back their money, and that too the 3 years limitation period is about to expire. Therefore, you please file a civil suit against the concerned persons. They also paid the fee as asked by the advocate, but Rangadurai did not file the case in time. Limitation period is over. So the promissory notes have become useless. So this is the problem. The old man, after wandering around the office of the advocate, see how many times he visited. So he came to know that the advocate cheated him. He did not file the limitation. Within the limitation, they did not file. Then every case is gone, is it not? You know. So he filed a complaint before actually district committee or disciplinary committee of the Bar Council of Tamil Nadu and Puducherry. Why? The inquiry revealed that the advocate knew the opposite party for the past 28 years because he has done their case particularly relating to a succession certificate under Indian Succession Act. So the advocate Rangadurai defended that he has entrusted the matter to his junior who failed to file the case in time before the court. No, not accepted. Whenever you take a brief under Rule 11, you have to pursue the case. You have to see that the case is plain, the suit is filed within time, because there is a damage. Because if you don't file it time, Section 5 is there, Section 9, you know. So when the limitation starts running, it will continue to run until it will not stop for you. So definitely, the advocate Rangadurai would have advised his clients at least to prepare, after all, suit. So pleadings and plaint, how much time it will take? So purposefully or inadvertently, we don't know. Because the senior advocate would have entrusted the junior would have been engaged. Otherwise, రకరకాలు జరుగుతూ ఉంటాయి. But he should not have done. ఇలా ఈ particular case, when the limitation period is there, no, we don't accept also. But it was done. We'll give whenever. So, on one or two occasions, when these people visit the advocate, the juniors did not make him have an interaction with the Rangadurai, and at the same time, they saw Rangadurai interacting with the opponent party. That's why justice should not be done, should not also be done, but should appear to have been done. Here also, they caused a prejudice. BCA said advocate should have made a frank and fair disclosure. Before taking up the case, Rangadurai should have told them, oh, that man, yeah, I know him. Yeah, I suppose, actually I have assisted him. I take up his case in that death succession certificate. Like, oh, do you want me to take up the case or not? If he had made a fair disclosure, this topic of disciplinary action would not have been there. So please remember, as per Rule 11, he has to take up the case. Rule 14, he has to make a frank and fair disclosure. Since he failed to the same, even though he was a senior advocate, he was suspended. definitely it is a clear case of violation of rule numbers 11 and 14. If you remember this much, it is sufficient. With this, I am concluding. Thank you very much.